Welcome to the LRF Group podcast, where we break down the critical issues affecting you. I'm your host, Luis Fernandez. Today, we are retackling a topic that has left thousands of tenants across Florida confused and at risk: the sweeping new rental laws that have dramatically shifted the balance of power between landlords and tenants. Before we dive in, I need to make something crystal clear. The information provided in this podcast is for educational purposes only and does not constitute legal advice. The laws are complex, and your situation is unique. It's essential that you consult with a qualified attorney for advice regarding your individual circumstances. The single most important changes that has upended tenant rights in Florida is a new statewide preemption law. In simple terms, the state has wiped out over 40 different local tenant protection ordinances that were in place in counties and cities across Florida. If you live in an area that had stronger rules, like requiring a 60-day notice for rent increases or providing other specific tenant protections, those are now gone. The state law is now the only law, and it generally favors the landlord. This means that no matter where you live in Florida, from Miami to Pensacola, the same set of rules apply. So what are these new statewide rules? Let's break them down, the biggest changes. First, notice periods. For tenants on a month-to-month lease, the notice period to terminate the lease has been extended from 15 days to 30 days. This applies to both landlords and tenants. So if you want to move out, you now have to give your landlord a full 30-day notice. Likewise, your landlord must give you 30 days notice if they want you to leave. However, be aware of loopholes. This doesn't apply to fixed-term leases that simply expire. If your one-year lease is ending, your landlord has no obligation to renew it and doesn't need to give you any advance notice unless the lease itself says so. Second, rent increases. This is a big one. Florida has no statewide rent control. With the local ordinance gone, landlords can now increase the rent by any amount they see fit, as long as they provide you with 30-day notice. A 50% increase, 100% increase, as long as they give you 30 days notice, it is legal under the new state law. Third, security deposit. Landlords now have the options to offer you a choice. You can either pay the traditional refundable security deposit, or you can opt to pay a non-refundable monthly fee instead. While a monthly fee might seem appealing upfront, it can be far more expensive in the long run, and you can get none of it back. Landlords cannot force you to choose the fee, but they must offer you the choice. Another major development is the new anti-squatter law, which went into effect July 1st of 2024. This law allows a property owner to have a law enforcement immediately remove an unauthorized person from their property without going through a formal eviction process. While this is designed to combat professional squatters, it poses a significant risk to legitimate tenants. If you have a verbal lease agreement, or if you're in a dispute with your landlord over whether you paid rent, a landlord could potentially misuse this law to have you wrongfully removed. This makes having written leases and proof of payment more important than ever. Let's talk about your rights when it comes to the traditional security deposit. The law is very strict here. Once you move out, the landlord has 15 days to return your full security deposit. If they plan to make any deductions, they have 30 days to send you an itemized list of the damages and costs by certified mail. If they miss the 30-day deadline, they forfeit their right to claim any of the deposit. Crucially, landlords cannot charge you for the normal wear and tear. Things like faded paint or worn out carpet are the landlord's responsibility. They can only deduct for actual damages you caused, and they must be able to prove the cost of the repairs. If you dispute the charges, you must respond in writing within 15 days. Finally, what if you need to break your lease early? The general rule is that you are liable for the rent for the remainder of the lease terms. However, Florida law imposes a duty to mitigate damages on the landlord. This means they can't just sit back and sue you for your year's worth of rent. They are required to make a reasonable effort to re-rent the property. Once a new tenant is in place, your liability ends. You can't just be left on the hook for the entire amount if the landlord makes no effort to fill the vacancy. To wrap up, the rental landscape in Florida has fundamentally changed. The key takeaway for every tenant is the need for vigilance. You must read your lease agreement carefully. Document every communication with your landlord in writing. If you have a phone call, follow up with an email summarizing what was discussed. And understand that the local protections you may have counted on in the past are likely no longer in effect. This is a complex topic, and we've only scratched the surface. I want to remind you one last time, this podcast is not legal advice. Please consult with a qualified attorney to discuss your specific situations. Thank you for tuning into the LRF Group podcast. Stay informed, stay safe, and I'm your host, Luis Fernandez. Until next time, all the very best.